So the California Consumer Privacy Act is a seismic shift in U.S. privacy law whose aftershocks will be felt for many years to come. It imposes dramatic accountability requirements for businesses that have never existed before, even under the European Union's sweeping general data protection regulation. The California Consumer Privacy Act is like the Sarbanes-Oxley Act for marketers. It's going to create a sea change in how business is done and the consequences of doing business in a way that isn't compliant. The simplest way to think about it is what one Fortune 50 chief marketing officer confided to me. He said he never wanted to be put in a position of having to explain why consumers in different places in the world have different privacy rights when it comes to the kind of ads and marketing that they're going to see. For many marketers, knowing what they can do and cannot do, plus what they must do, is going to be a recurring bad dream, but one they're going to have every night for a long time. The simple fact of the matter is figuring out what you have to do and how to do it under these laws, especially California's new law, is incredibly, incredibly difficult. And one of the only ways that businesses end up making these decisions is rather than parse out all of the exceptions to the exceptions to the exceptions, they go to the lowest common denominator. And what that's going to mean for marketers is a lot of really good marketing isn't going to happen because it's too expensive to figure out whether you can do it, when you can do it, and how you can do it. And some might say that's a positive unintended consequence, but if you're a marketer who's trying to realize the dream of personalized marketing and advertising, the California Consumer Privacy Act is a really, really bad news for you. Well, the first is data breach liability. The CCPA imposes express penalties of size and magnitude that we've never seen before, and the law guts many of the defenses that we've used as lawyers to prevent those lawsuits from succeeding, and we've relied on them for years. For businesses, this means that the risk attached to the same information we've always collected now has increased dramatically, and many businesses have little genuine understanding of what they have, how they collect it, and more importantly, how the risk has changed. It's almost as if they've discovered that they bought a house that turned out to be a Superfund site. And many companies are going to be quite surprised because the ability to react to what the law is and what the law requires is going to change dramatically. The second factor is accountability. Knowing what a business has, who you share it with, and being able to tell consumers when they ask you who you've shared it with in the last 12 months in a really granular way is a legal requirement that's unlike anything we've dealt with before. While enforcement can't begin before early 2020, middle of 2020, as the law is currently implemented and enacted, it will have a look-back period beginning with January of 2019. So businesses are already likely going to be unable to comply, at least in Q1 of 2019, when these requests come rolling in 2020. We either need relief from the California Attorney General or we're going to need a legislative change. But in any event, many businesses are going to be caught unprepared. The third thing that happens with CCPA and major implication for marketers is vendor supply chain management. So the law has very specific requirements on vendors and suppliers. So if you work with vendors and suppliers, you need to change your contracts with them, and this will mean changing thousands of contracts with no new consideration. You have to negotiate. Very, very difficult thing. Additionally, what people in the field call third-party risk management is really changing radically. Security pros and other people that work with these companies are going to have to completely reevaluate them because there are very, very large penalties for data breaches, that first point that I identified. So if you have vendors and suppliers that historically you thought were low risk, now those risks could be huge because the financial penalties of a misstep can be enormous. First-party data is always a lower risk under the current ways that we do business because first parties, people that know who we're doing business with, can communicate directly. Whether we understand it or not, consumers are wary that their every move online and offline is being tracked. When consumers trust the people who are doing the collection, something they're more likely to do in first-party relationships, establishing and sharing data is much easier. For everyone else, the current notice and choice regimes provide little comfort. The kind of sharing that goes on in online advertising occurs in many industries. It happens with creditworthiness and employment screening. Those are just two examples, but they're highly regulated, and consumers and advocates have been understandably skeptical given daily headlines over the last few years. So the reality is, first-party data is definitely going to be something that's easier to use. It's going to be easier to target ads. It's going to be easy to market. But connecting streams of data across unrelated websites, unrelated services, online and offline data, all of that kind of thing is going to be much, much more cumbersome under the California Consumer Privacy Act. I think we have to realize that the tech landscape changes very quickly. So today's dominant company won't necessarily be tomorrow's dominant company. But one of the things that's really important is that the larger companies, some people might say big tech, often have important first-party relationships, which gives them a strategic advantage over smaller players and third parties when it comes to complying with sweeping regulatory requirements. Many of these companies might use their leverage, understandably, to compete and differentiate themselves. But what's significant about the California Consumer Privacy Act and the GDPR is the unintended consequences of these laws. They may strengthen precisely the kinds of companies legislators who criticize big tech want to rein in. These companies can spread their compliance costs across larger revenue bases. They have larger user bases, so it's totally understandable that it's easier, simpler, and faster for them to be able to meet these new legal requirements. And that, in some level, is good for consumers, but it may be very bad for innovators and other smaller companies trying to do things that haven't been done before. So overall, the answer, I think, is larger companies will likely continue to get larger and have an easier time complying. Innovative companies, smaller companies, companies trying to do things that are very creative, and marketers trying to do those same things are going to have a much tougher time. The menu that's going to be available to them will often be the menu that's available from the bigger companies, and that should come as no surprise.